have something in his file that should have said, you should have a foundation inspection. If you don't want it, that's your decision. And I know he doesn't. And frankly, I learned just recently, if you're ever doing anything in San Francisco, that all those old houses are built, the concrete is built with sand from the beach.
Oh, wow.
Whoa.
The foundation with sand in the beach creates little pockets of holes and stuff and creates a problem with the foundation, and they will fail because they don't use the kind of stuff they use in concrete today, and they certainly didn't have any rebar. And I talked to a structural engineer who said everybody knows that. Well, I didn't, but I'm not a real estate agent in San Francisco.
So I have to be very careful.
And I think that's the knowledge that a San Francisco real estate agent should have. Victorian house on a hill, let's look at the foundation, because if it's made out of sand, you could have $100,000 fix.
Going back to arbitration, isn't it better to not tie your clients down, buyers or sellers, by insisting? I know many agents do that. They insist that you initial this. My policy is that we don't need to initial this. We can choose later on based on the case whether we want to go go to the court with a lawyer or go into arbitration after mediation.
You can always agree on anything. You can even file a lawsuit and get that driven over to mediation. The problem that you run is that if your client says, okay, now I want to arbitrate, because I now talked to an attorney who said it would be quicker and less expensive, the other side says no, you can't force them to do it. If you don't sign, you've given up the possibility of doing it unless everybody decides to do it. If everybody signs up front, you can force that. You bring a lawsuit in, and I've done this before, where they've initialed the arbitration, then they refuse. So I just bring in a lawsuit in Superior Court, and the judge says, you're going to arbitrate. Don't come back here until you're finished.
But wasn't that what you just said before, that arbitration is kind of, not a sure thing based on the person you get in front of it there, right? I mean, if his decision is not the best decision, you can't appeal.
To be fair to you, you could have that judge make a decision, and then you say, well, yeah, if the judge makes a decision because he doesn't know the law, I can appeal. You know what an appeal costs? They're $35,000 just to start with. So now you're looking at arbitration costs, litigation costs, appeal costs. Unless you have a big pot of gold, or you have CAR or NAR helping to fund the lawsuit, most people can't afford this kind of thing. I still think you're much better off in arbitration. Be careful who the arbitrator is.
Okay.
Just don't make it some guy who doesn't know a residential contract from a dog biscuit, because then you run the risk that he or she's not going to understand. I'll tell you, you have this problem sometimes with the DRE, because when you go into Oakland and you do a DRE complaint, the judges up there hear wage and hour disputes, they hear workers' compensation stuff, they're administrative law judges. Anything that's under the administrative law umbrella is heard by the judge. And we were up with a client of mine, and we were speaking real estate speak, and the judge kept interrupting. I don't understand what an REO is. I don't understand what is a short sale. And I said, we took a break, and I said, don't use jargon. Speak like this person does not know anything, because you're fogging her up. She's getting so confused. We can't argue what we want to argue because she doesn't know the vocabulary. And the reason she doesn't know is because she's not a real estate judge, and she doesn't do these. You find somebody who's done 100 of these cases, and you don't have to educate them as to what an REO is or a short sale.
Plus, arbitration usually takes like 6 months to 2 years, where a lawsuit can take 2 to 5 years.
Well, there's a 5-year statute that through the date you file a lawsuit, it has to be tried within a 5-year period. The judges are pretty strict about that. But arbitration is going to move faster.
And it's cheaper.
Yeah, it usually is cheaper, although you don't have to pay for your Superior Court judge, and you have to pay for the JAMS judge. But most people want to get it over with and not get behind them.
Okay.
How are we doing for time?
Just one question that Helen had. She wanted to know with the short sales that a lot of her investor clients don't want to give the deposit because they think it could, then first of all, it's not assured that they're going to get it. Money could be tied up for 90 days, 9 months even. So what do you do in that case if they don't want to actually, do they have to put the money in for deposit?
Yeah, I don't think you can get around that, because I would argue there's no consideration for the contract. There has to be some monetary consideration. If you don't put the money up, then I think you can certainly argue from the bank standpoint that, and the bank's not going to allow you to go enter into a short sale contract without any money up, are they?
Right.
Oh,
Well,
Sometimes they don't know.
well, that
Oh,
was-
they don't pay any
Well,
attention?
see, what you just said with regarding consideration, that's what happened with a triplex I did in Hayward. I had my client put in the money, so there'd be consideration. Technically, we were not, we're in contract when she accepted the offer. But what this agent did was, in fact, it was another Remax agent, she ended up coming back and then after saying, oh yeah, I got it approved, but someone else submitted an offer after and it was for more money, and they went with that offer, which my client was upset. I said, you can't do that, and she did that. Oh yeah, we're just gonna release you your deposit. But then I said, that's why I had them put in the deposit.
Well, I think,
exactly so you
I think the
wouldn't
bank
do
is
that.
free to accept or reject your offer.
But also the after acceptance is actually when after the bank accepts it.
Right.
So even your 3 days after acceptance isn't necessarily when the contract is signed by the seller.
Aren't they going to give you their own contract?
Yeah, and that usually takes.
well, the short sales, there's
Right.
an amended, but not quite as extensive as the bank-owned properties. But that's just unethical. As a short sale listing agent, if I accept her offer and her client, even the sellers, and we're at the seller's point, they have signed an offer. It's accepted, I take it to the lender, that being the best.
Yes,
to
either
take.
accept or reject.
And if they, I would rather they put a little bit of money, doesn't have to be the 3%, but just to show that they are serious and, follow through with the transaction. It would be unethical for me to go and get a better offer.
So do you have to put the money in or don't you?
Well, I think if you're using the car contract, you have to.
You have to.
But it says 3 days after acceptance, but acceptance does not start until after the bank has sent approval. We have that other addendum.
Oh,
But that's the fine line what I'm saying, because I went through a car course to get CE certified. They said, the short sale, do a standardized contract with the addendums they were stipulating,
Right.
but you go through the process of your client accepts an offer, it doesn't become fully accepted until the bank does, but technically the whole process comes in, like she says. So when I do my short sales, everybody submits their offers on whatever specific date, you go with that, and that's what you're going with the bank.
you
unless
put the
they-
money up?
Yes, I have them put the money in escrow because I know they're going for it, and they're not shopping you around and they're committing.
Right, I think you have to, and if the bank rejects the contract, they have to give you the money back.
Right.
Yes, but what I'm saying is what happened in my case where the agent accepted the offer, everything went in the process, but then decided, okay, hey, the bank is accepting someone else. I know what she did. She just went with the higher offer and then probably told the bank, hey, these people pulled out, did whatever. It was unethical on her part, you know what I mean?
Typically, the banks don't want any other offers.
Yeah, but in
Right,
this
they
case, she
just
got
want
away
one.
with
She
it.
probably
Yes.
never submitted your offer. She got something.
But she accepted the return.
She accepted it and had me put the deposit.
Does he have any reports?
He might have an ethical violation.
But I mean, that's what that sounds
Yeah,
like.
but then that's where, but then once again, it's like you said, it's just going through the
You're
process.
gonna have to
and
spend your
doing
time,
it.
you won't get any money for it.
No, right? It's just,
The situation that currently pops up.
know.
My house, I agreed to pay for section 1 report that they
You have to give
provided.
up a buyer. You get a-
About $9,000. So I paid that, house closed. Now the agent is representing the buyer, wants additional $5,500 for some items that came up during just recently in a supplemental report submitted by the termite company. So they went in and
Also
did
section 1?
an additional report, even though they already have their,
I tell them no. You offered to pay that based on the initial report that said $9,000.
right, not a supplemental report. So now he's saying that Carr Legal has concurred with them and that I am legally responsible.
How does the contract read with regard to all section 1 work?
It says section 1.
Yeah, all
work,
section 1 work,
Period.
yeah.
But per the report is,
So what they
So
did
did you
is,
have an addendum or something that says per the report?
it's
No.
in a work request.
yeah. And then
There's
when they were tearing the place apart, oh, we found more extensive damage, up to $5,000, and they sent that.
Which isn't even in the area, which the other section 1 work, they said they're in the
That's
windows.
the
That was,
Inspection company, right? And now with.
I So but the thing is, they're gonna sue me. He says I'm legally responsible
The
for
$5,000?
$5,500. So then they could do more inspections and come up with another 5,000 every month now for the rest of my life.
Wait, did you agree to do thermite clearance? Is that what he wants?
I already gave them $9,000 for the report that was submitted to me prior to close.
So, but did you just give a credit or did you agree to give them a
I gave them a
clearance?
check for $9,000.
I know, but what were the terms? Was thermite clearance or just a credit
Section
towards?
1 for the,
Yeah,
for the.
so what,
section
so
one.
they, because I don't know, this happened to me years ago, but, we stipulated on there that per the section 1, whatever was we agreed to allocate, we will not allocate any more money if there were any findings. So they came back and they tried to say the same thing to us, saying, hey, they opened up the walls or whatever, wherever the section was, there's additional
Yeah.
work that
Yeah,
needs to
but
be
we
done.
didn't.
But in our case, since
You
we
didn't qualify?
capped it,
Well, I had a verbal, I talked to him, I go, I'm only gonna do this one for this report, only the $9,000. I go, I need you to know that. He totally agreed
But
it would
does-
only be $9,000, that's
But
it.
does your agreement relate back to the work order? I am going to pay what's on this work order, $9,000? No. It just says section 1.
It was
I see- I
attached,
see that
it
argument.
was in all together, and the report is with the work request, and it was that number that was on that report. So it wasn't, has anything to do with some supplemental report. Now they're saying there's a supplemental report that I received today.
It's already closed escrow.
They already closed escrow, but they're still doing supplemental reports, and they can keep doing supplemental reports according to contract.
You know,
So I didn't
I'd fight
specify
on
a
it.
cap.
You didn't cap it.
I didn't
I'm not
cap
saying
it.
it's right or wrong, but that's
No,
what saved
it
me.
is
I
wrong.
capped
It
it.
capped
Wording we
it.
should
I
use
capped
to
it.
put cap on that. What kind of wording we should
Well, not only
use that?
cap, how about the
At
date
end
of
Well,
the
you could
report?
say, seller is responsible for all section
Close.
1 work, not to exceed $9,000. That takes
Okay.
care of it.
Yeah, that's what I thought I wrote, and I,
Double check that.
Or you can
it's
put,
not that way.
or you can put
Why
as
don't
per
you double
report
check it?
dated.
Yeah.
As an agent, after we close the escrow, can we have the client to sign the liability waiver?
For what?
Because when escrow closes, it's closed. You cannot come back to say, hey.
Well,
more
I
reports.
don't think so. And the reason I don't think so is there are a couple of, well, there's a whole bunch. I just wrote
I
an
know,
article.
I know where you stand.
Yeah, I don't think it works. I may have
Okay.
drafted it for him, but I don't think it
So
works.
am I gonna go to
Small claims,
small, because it's under
$10,000.
$10,000? And what if they keep coming back each month saying there's another report?
Well,
another
you
report?
want the small claims judge to rule if you're liable for anything over and above what you already paid after close of
Okay, so the
escrow.
worst case scenario is that I'm gonna have to pay $5,500, or am I
Well-
gonna have to pay additional?
For all you know, you're building them a new kitchen,
So does that,
right?
You're
Uncle
right.
Ned is a termite.
So I don't wanna pay the $5,000.
No, I'd fight it. I don't know if you'll win, because you haven't qualified or capped it. But here's the issue with the trying to get your own client to indemnify you. You have a 2-year statute of limitations in, I think it's 17200 of the civil code that says that your client can sue you for not doing a reasonably diligent visual inspection 2 years after, and there's a whole laundry list, but just think close of escrow. So you can't have them waive that, because if something happens and they say, you didn't see whatever it is. We've got one right now where the floor slopes and the foundation has to be replaced. Well, the agent didn't see that, and now when the agent's attention was brought to it, they said, oh, God, I screwed up. Yeah, and the inspection company screwed up. So you can't waive that 2-year statute of limitations. Also, you have other liabilities. You have fiduciary duty breaches, which are usually triggered by a 3-year statute of limitations that runs from the time that you discovered the breach of the fiduciary duty, or reasonably should have. That's the good old weasel words that lawyers like. Reasonably should have discovered the breach of the fiduciary duty to bring an action against you. Those statutes can after close of escrow, put your liability on quite some time. If it's something that you should have seen but you didn't see, that's hidden and not discovered till later on, that starts triggering that 3-year period. You can't ask your client to waive it. I mean, you could, but I don't think there's a court that would uphold that, because they're saying you're obligated by law for these things. Now you're asking your client, probably without explaining it to him, that he's signing something to release you. I don't think a court would allow that.
Does that mean, if you put asset sale, does that still apply? If like her case, if they put assets?
Well, that's apples and oranges. This contract that we just went over has as-is language in it. I think that's pretty standard. But that doesn't get you out of doing a reasonably diligent visual inspection. You still have to do that, whether it's as-is or not as-is. All as-is says is the seller's not making any repairs. Whatever you see is what you're buying.
Right.
But you still have an obligation to do a
For
reasonably.
agent, right?
Yes.
That's like for her case, then if it's asset sale, then do they have? still
No,
have to
because
pay?
there's a provision in that contract that says seller's gonna pay for section 1.
Oh, I see.
That's where you gotta be careful. If you already have your section 1 report, because we had that San Francisco with the foundation thing I told you about, seller was obligated to pay section 1, but nobody did a return my report until they were into the contract. $23,000, thank you very much. And they weren't happy about it. But they didn't modify and cap it. Seller will pay section 1 termite repairs not to exceed, pick a number, or not to exceed what's ever in this report.
Right, so what if you put in the wording like, seller credit $9,000 for any and all repair pertaining to this property?
If you want to cover section 1, then you got to be real specific.
Cap
You capped it up to
You
Yeah.
no more than whatever
more
may
than
be.
$9,000.
Cap
For
it.
any-
Including
Stop
but
it
not
at that
limited to
report,
section
what that
1
report
termite
says.
repairs.
Her
What
report
seller
dated on
is-
like not to exceed this amount, and then write out the amount.
Every transaction we should cap.
No, I disagree. If you're going to if you want to include any and all repairs, you better specifically say section 1, because there's a specific
Okay.
paragraph that says seller fixes section 1, buyer does
Cap.
section 2. So if you're going to cap it, you say any and all repairs of whatever nature, including but not limited to section 1 termite repairs. Then you're golden.
Can you repeat how you said it? Seller?
No, I can't ever say the same thing twice. Seller shall not be liable for any expenses beyond $9,000 for repairs or section 1
For any and all
repairs,
repairs.
any and all repairs, including but not limited to section 1 termite repairs.
And that's being that, the report having that $9,000. Right.
I just wanted to ask, just real quick, because it happened to me. I was doing a short sale on a property. The seller, there were some people that, the person that used to be on title illegally put some people in there, so he was trying to do an unlawful detainer, hired a process server. The process server, when he hired him, he called me saying, I hired the process server to serve these people, but there's a few people in there, I don't have everybody's name. I went down to the process server's office and said, hey, listen, they're gonna foreclose on this property. If you're gonna process serve, you have to physically process serve the 5 people. You can't do a process service in the mail because the property will be foreclosed on. That's all I told the guy, but my person hired him for service. Long story short sale sold. I was able, everything was done. He didn't serve them properly. He did service of mail. So once that happened, I had to go and get somebody else to properly serve these people. Transactions closed. All of a sudden, I get a small claims lawsuit, right? Luckily, it's only for $360 that he didn't even serve me. He had served Judith with, and I was like, why am I listed on this? So my client that hired him for process serving, right, never paid him because he said you didn't do the job right. We go to small claims court, my client doesn't show up, I show up, and the judge asks him, why are you naming Mr. Ocon onto this? He goes, well, he's the listing agent. And he told me, he hired me for the client. So I told him, no, I didn't, and I explained to him what I specifically said when I went to the office, and the judge was like, fine. I thought, there's no way. I come back, the judge ruled against me and added me onto the service and ruled against both of us for the process serving fees and added $250 onto that.
Oh, wow.
That's horrible.
Next time, go to Judge Judy. I was like, these small claims judges, they're either commissioners who are actually sort of.
This was a commissioner, which wasn't, I should have not used him.
No, you can, if you go to small claims court and you're not comfortable, you can ask for a Superior Court judge and bounce it back upstairs.
Yeah.
You get a much better shake,
Yeah.
because a lot of times they just look at, you don't look like you have any money and you look like you have some money, well, just give her money.
Yeah.
I think that's what they do.
Yeah.
So I guess my point is that, can that happen basically with almost anything? Because I was like, he was a process server where he brought in receipts and proof of everything, billing my client. Nothing was under my name, and he still ruled against me, which was shocking to me.
Yeah, because they're.
No, I think he's wrong.
Yeah.
Yeah.
But then what are you gonna do? You
Yeah.
can appeal it.
Yeah, I know, and then I appealed it, and then it goes to whatever, and they're like, oh, no.
They automatically, we appealed one, we appealed one, we thought we
Terrible.
would've just had a great appeal. I think they routinely throw them out because they don't wanna bother with them.
Yeah.
Ron had a question, I think. Did you ever long ago?
Yeah, well, I deal with the arbitration situation a lot in terms of my clients saying, should we sign this? And I basically say, well, it depends on the situation. I mean, if there's going to be multiple offers in, they're going to want this in there. But if you're not pressed on that, I say I really don't really think you have to, particularly since they quote things in here like Civil Code Procedure 1283.05, and where is that in the contract? I don't even know what that says, and you're saying you're going to waive your rights. So I tell them, don't sign it.
Yeah, you're waiving your right to a jury trial.
Yeah.
And, yeah, I guess the best answer to that is either, I can't give you legal advice. Arbitration is typically a shorter process and probably a little bit cheaper process. You can't have, a lot of people are afraid of juries because they think that juries, even though they're not supposed to, will act on their emotions rather than the law, and they'll make a ruling in favor of somebody because they feel sorry for them, which you're not supposed to do. But when they're in the jury box and talking to one another, who the hell knows what they're saying? So then, in banks, for instance, you can't sign a bank document that doesn't make you waive your right to trial by jury, or you're not getting the money, because they don't want to be in front of a jury and say, greedy, stinking bank, and so everybody wants to punish the bank. They blame them all for this housing mess.
I let them know that, regardless, they're going to have to go to mediation if there's a
Absolutely.
dispute. So I tell them that, and I said, but you don't have to really sign the arbitration.
You don't.
And
Well,
sometimes I'll get-
this lady said over here, you can always change your mind and agree.
yeah.
And both lawyers can say, why don't we just put this, I had one that there was no arbitration here. They didn't even have a written contract. They built a $4 million property and have a written contract between them for a partnership. Bunch of knuckleheads, basically. And so they said, I talked to the other attorney and I said, this is gonna cost a ton. Let's go to arbitration. Who do you like? Let's use this judge. Okay, fine. Let's limit it to 1 day. Okay by me. We did it in 1 day. We got everything done. And that was much cheaper than going to litigation and spending God knows how much money. Worked fine. I won. I was happy. I shouldn't have.
Ask you another question. For the arbitration, if your client wins, they need to pay you, or another?
Oh no, we work for free, just like you guys. Yes, they. Yeah, I have a contract with my client. My client has to pay me. He can go get it from the other guy.
He can get it from another guy if
Yeah.
he wins.
Yeah.
Okay, but if
That's not my responsibility. I'm not going to collect from the other guy because I don't have a contract with that guy.
but if they win the case, they can claim the.
Yes.
But if, let's say, the case you have, they want to claim for 120, but later they settle for maybe 50. So it's a cycle. It's not really win or lose. So how can they claim?
The judge will determine who wins and who loses.
Oh, okay. All right.
If you say I'm not paying you anything and the judge awards me $1,
Okay.
I'm the prevailing party
Oh, okay.
because I got more than you got. Now the attorney's fees could be $50,000.
Roger? Speak to agent facial inspection. Is that right? Handwritten? Can we take photo?
Yeah, what's going on right now that I'm finding that I think is really, really helpful, especially with digital cameras, almost
Yeah.
everybody's got an iPhone
Yeah.
or a Droid or something, is to take pictures of the stuff that you notice.
Okay.
For instance, if you say, small crack in the dining room, what the hell does that mean? I don't know what that means. I don't picture a crack this long,
Yeah.
but I don't know if it's this long or that long, this thick, that thick. You take a picture of it, there it is.
Yeah.
So you gotta, so not only does it trigger your memory when somebody's saying, you mentioned a small crack in the sidewalk, small crack in the
That's why I
dining
stopped to
room.
go to photo.
Here, yeah, I remember that, I took that photo. That, there, you don't have to have attorneys parsing your words as what you meant by small, or medium, or large, or whatever.
I always tell them not to quantitate it or
Yeah,
qualify
absolutely
it, just
not.
say crack.
Yeah.
Don't say big, small, large.
Can you
Yep.
refer to, if you have a home inspection, can you make a note or something and just say, and then refer to the home inspection page?
I don't like that, because the law requires you to do a reasonably diligent visual inspection, and I see so many agents, in that blank, say, see reports. Well, what are you doing? You're supposed to walk the property. You're not a general contractor,
Right.
although if you are, you're held to a higher standard. But if you walk
You
around,
can copy
The wording.
inspection report.
Oh, okay.
Wherever they took, we just take and copy the same wording.
but you should,
Yeah.
here's how that's gonna be used against you. You say, refer to the reports. And the other attorney is gonna say, you didn't do a reasonably diligent visual inspection under 1700 of the California Civil Code, did you? Yes, I did. What did you see? Well, I don't remember. You didn't note it here, did you?
Okay.
So the question is this, the pictures that we take, do we include them with that report or we just put them in the file?
I would put them in the file.
Okay.
Here's the problem, you guys are gonna get dragged in, when something goes wrong with the house, everybody gets in the boat. Listing agents, selling agents, you're all gonna get named, because why? You have E&O insurance.
Yes.
We have deep pockets.
They
Pocket.
don't want your money, they want the insurance.
But in that case, I have a question for you. Wouldn't it be to my advantage to then show the pictures and disclose them even as I saw it at the beginning so that if you had them, why didn't you disclose them? No?
No, you're doing more than you need to do. You only have to do a reasonably
Save your
diligent visual
ammunition
inspection,
when
but
you need it.
look at yourselves as potential victims of a
Yes.
lawsuit. Now, you're having a deductible probably at your office. God, I've seen them as high as $25,000. I know what yours is. But when the agent gets told that they have a $25,000 deductible, guess what they do? Can I have my license, please? I'm going to another broker, because they're not going to pay it. But the broker still has to pay it to trigger the insurance and get the additional coverage. And that's what happens all the time. People bail, stick the broker with it. Now the broker has to chase this clown around for $25,000, and because you want the insurance. Because who knows how much you're going to spend in attorney's fees. So you have to have the insurance. And I have some brokers who say, well, I don't really want to give it to the insurance company, it'll raise my deductible. That's what you have it for. And it's probably not going to raise your deductible unless you're getting sued every other day. If you have one claim against you in 5 years, if you have no claims against you in 5 years. Sometimes people don't get claims for 30 years. I've had clients, no claims 30 years, and all of a sudden, bing, 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 they got 3 lawsuits.
Whoa.
No insurance. They didn't have insurance because for 30 years, nothing happened. But the day that you needed it, and this is a particular client who ran up close to $80,000 in attorney's fees and probably paid out $100,000 in damages. How do you throw that over 30 years? It's probably still a fairly big number.
I have a case for short sale, and just before close escrow, the day we went to back to the house out there to see if there's a big damage on my store, and before that happened. And my client still want the house. And
You do?
there's
Yeah.
tons of
On
junk
Sundays, he comes to
in the
my store
garage.
once a year.
So
Yeah, so you have to
what should I do? I called
Is
the
it
leasing
closed
agent.
escrow?
Yeah, we closed the escrow. I called the leasing agent, and the leasing agent came over to see it, and I told her, I will conduct the other junk, but you
26 at the office.
you would take
No, that's my
those,
next door.
the junk from the car, from
Is
the
this
pillows,
us?
from
Okay.
stuff,
Wow, then it's
something,
been
the
us
chemicals
twice
that
too.
not gonna leave to my client. And she said, yes.
You have one?
And second day after we close escrow, she's disappeared. And never answer the phone call, and never give us some form back.
What you should have done is made a visual inspection of the property
Don't
before you
use
close and insist on
expensive
that
stuff
stuff being
doesn't
taken
work.
care of before you sign on.
But we can't. It's found already in the escrow, and we're gonna close next day. So.
Well, your client could,
This
what
is
your
a
client
small
probably.
damage,
Huh?
but what happened bigger damage?
You want small damage. Well, it's gonna cost something to clean out the garage, and if you have.
I cleaned it up. It's not cost, it really didn't cost me because the contractor helped
That's what you
me.
do.
But, yeah, I did great. So what about the bigger happen, cost more, so what do you do? The leasing agent is disappeared.
Yeah, but it isn't the listing agent's responsibility to take care of that, it's their client.
I know, but you cannot call them all the time and write email and write a letter all the time and they just don't show up. You can't get that. I want the house.
Yeah. Well, I mean, if they incur damages, they can go to mediation with the seller.
Is any, like a letter or complaining to the board, is it?
You haven't had anything in writing.
Yeah, I did.
Thank you so much.
This was excellent.